Have you or your loved one been arrested? Here's everything you need to know. Well, crap. You or your loved one got arrested. It's devastating, scary. Ugh, I feel for you. So what happens next? Well, soon after an individual's arrest, she or he will appear before a judge for what is called a first appearance or an arraignment. Firstly, let's learn about arrest and the legal principles guiding them. In police terminology, an arrest occurs when a person is taken into custody. An arrest does not automatically result in incarceration. For example, on what I mean, an infraction results in a traffic stop. Drivers may be considered arrested since they are not free to leave until the officer writes them a ticket. The detention is only temporary. When a ticket is issued, the driver will usually be released after presenting identification, insurance, and signing an appearance promise. Charged without arrest? Is this possible? Totally. Many states have an alternative procedure referred to as citation. Citations can be used instead of arrest for traffic infractions and minor misdemeanors, like shoplifting. In exchange for being free, a person who signs the citation promises to appear in court on or before the date specified in the notice. But why citations? And how are they useful? Overcrowding is a problem in many metropolitan jails. As we all know, the ever ineffective tough on crime is the genesis of the issue. In some cases, jails are required by law to limit their capacity. Due to this, many police departments instruct their officers to issue citations to suspects who were previously arrested. It does, however, have the unintended consequence of allowing suspects who could benefit from going to jail and cooling off to remain free, posing a safety risk. What limits does the Constitution place on police arrests? To be lawful, an arrest must abide by the Fourth Amendment of the U.S. Constitution, protecting people from unreasonable searches and seizures, and requires warrants to be issued only if probable cause is shown. Probable cause defined. To establish probable cause, the police officer must present objective facts that indicate the suspect committed a crime. Probable cause is determined by judges, not by police officers. Even if the police were wrong, probable cause to arrest might have existed at the time of the arrest. So what about our probationers and parolees? Probationer and parolees are generally exempt from the probable cause requirement. Probationers and parolees are frequently required to submit to arrest and search without probable cause. It does not mean that police officers can arrest probationers and parolees purely to harass them. To make an arrest, police officers must generally have reasonable suspicion that a probationer or parolee is involved in criminal activity. Again, what's reasonable suspicion? Again, our courts that favor police officers get to determine this. We've really got to clearly define it. What happens if a judge rules that a police officer acted without probable cause? Well, arrest warrants are not issued unless the judge believes there is probable cause. Except when the suspect is arrested at home, police officers can make warrantless arrest without a judge's permission. The judge may rule that warrantless arrest lacked probable cause, dismissing the charges and releasing the suspect. When a judge rules that an officer lacked probable cause, what happens? Evidence is excluded. A police seizure made in connection with an illegal arrest is usually inadmissible in court. Tort action in civil court. In a civil lawsuit, an incorrectly arrested person may be able to sue both the arresting officer and the city. The only time a cop gets in trouble for an improper arrest is when he physically abuses a suspect. Removal of the arrest record from the arrestee's record. This may necessitate the filing of a petition with the court requesting that the arrest record be removed. Probable cause emerged after the arrest. A judge's ruling that the police lacked probable cause at the time of the arrest doesn't always mean the defendant can leave. The police may have gathered sufficient information by the time the judge makes that decision. In these cases, the defendant may be released only to be promptly rearrested based on the new evidence. Caution: a police seizure made in connection with an illegal arrest is usually inadmissible in court. It is risky to resist even an illegal arrest. Rather than litigating issues like probable cause on the street, legislators and judges prefer that arrestees not resist police officers. Some states, however, allow someone who has been wrongfully arrested to resist with reasonable force. Resisting an unlawful arrest is generally not a good idea, even if reasonable force is allowed. You know whose favor it works in. Better to not test it. Despite the arrestee's innocence, it may be legal to arrest. Not to mention, it can quickly lead to a situation in which the arrestee suffers serious injuries or incurs additional criminal charges. Remember that resisting arrest differs by state, and that the offense can usually be committed without force. It is possible to be charged with resisting arrest even when the officer is not applying handcuffs. Depending on the statute, the crime may be complete if the person fails to obey a lawful order issued by an officer. Arrest warrants. Arrest warrants defined. A warrant of arrest is a court-signed document that authorizes the arrest of the person or persons named in the warrant. Crime stated. An arrest warrant indicates what crime has been committed and may limit how an arrest can take place. Specificity of warrant examples. Woo, that's a hard word to say. A warrant, for example, may state that a suspect may be arrested only between 6 a.m. and 6 p.m. Bail instructions. A warrant may also specify how much bail a defendant must post to be released. Ready to be in action and create change? Keep in mind the 8th Amendment to the United States Constitution states, excessive bail shall not be required, nor excessive fines imposed. We gotta do something about this, you guys, and it starts with holding them accountable by creating civil lawsuits. If the warrant is for a prior failure of the suspect to appear in court, called a bench warrant, it may state that the defendant may not be released on bail at all, called a no bail warrant. When making arrest, do police officers always need arrest warrants? Nope. The arrest is valid as long as the officer has reasonable grounds to suspect a felony. Generally, for non-emergency arrests or arrest for misdemeanor crimes they did not witness, officers generally need an arrest warrant. Here is the process of obtaining an arrest warrant. Officers submit a written affidavit to a judge or magistrate in order to obtain a warrant. Affidavits must establish probable cause that a crime was committed and that the person named in the warrant committed it. Overly general description that could apply to a great number of people will not suffice. Let me give you an example. a judge will not issue a warrant to arrest, let's say, Ross Rosenberg, based on an affidavit that a bank was robbed by a bald, pot-bellied male of small stature. However, if 5 witnesses and the bank teller identified Rosenberg as the robber, then Ross would most likely be arrested on probable cause. Well, what if there's incorrect information in the arrest warrant? Due to humanity, factual errors occasionally occur in arrest warrants. There could be a spelling error in the name or a mistake in the crime description. Ideally, a warrant should be shown to the suspect. Now let's talk about warrantless arrests. When are warrantless arrests legal? They are legal when a crime is committed in front of an officer. For example, a police officer may see a person finish their drink and drive away as they leave the bar. The officer has the authority to pursue and arrest the driver. A police officer can arrest a suspect for committing a felony with probable cause, regardless of whether the act was committed in his presence. Let me create an example for you. Officer Murphy comes across 2 ladies who possess and appear to be under the influence of Molly while on a routine patrol at a fish show. Lucky officer, getting to go to a fish show. They tell the officer that they just bought the Molly from the guy with a yellow shirt while pointing his direction. These girls obviously don't know that snitches get stitches and wind up in ditches. I kid. The officer sees a suspect matching that description sitting on a bench near the crowd and heads his way as there is probable cause to arrest the suspect described by the concertgoers. Although he did not witness the suspect selling Molly to them, drug dealing is a felony. The officer had probable cause to believe that the suspect committed the crime based on the dealer's appearance and information received by the women. All right, enough of all the silly, wonderful, beautiful fish examples, who happens to be one of my favorite bands. Let's sum it up. A warrantless arrest, in general, is permissible if there is probable cause, with the exception of misdemeanors committed outside the presence of the officer. Wowza, this is a good one to know in today's unfortunate political landscape. In San Francisco, we use our voices. Protests are plentiful. And just so you know, they're effective. And I love every second of it, even if I don't agree with what's being said. Use your voice. Also, know your rights. Let's talk about it. During a protest, what can the police arrest you for? Well, police can make arrests when a protest becomes a clear and present danger and an immediate threat to public safety, peace, or order. If a protest is violent or poses an immediate threat, police may declare it unlawful, issue a dispersal order, and arrest anyone who refuses to leave. If you break a curfew imposed during ongoing protest, you could be arrested. Demonstrations obstructing traffic on city streets or sidewalks may require permits in advance. Traffic blockers will be arrested. Be very clear. The First Amendment gives you the right to film and photograph police officers as they perform their duties in public. Simply because the officers don't agree with what you're doing, they can't force you to stop recording or show them what's on your phone. You could be arrested for interfering with an officer's ability to perform their duties. So record from a safe distance so you won't be accused of getting in the way. The Safe Access to Abortion Services Act of 2017 prohibits protest, sidewalk counseling, intimidation, physical interference, and recording or photographing patients and employees within buffer zones. A buffer zone is designed to keep protesters away from sensitive sites such as abortion clinics, and this may also lead to arrests. All right, in today's post-George Floyd's world, let's get clear on the legality of force used by police. So when making an arrest, the police can use what type of force? Generally, police officers do not have to announce their presence in advance if they are pursuing a fleeing suspect, suspect that someone is being harmed in the house. Announcing their presence may put them at risk. And finally, by announcing their presence, suspects could flee or destroy evidence. Well, what constitutes reasonable police force? Police officers are allowed to use reasonable force to take someone into custody. Unreasonable. A police officer cannot beat a suspect who only attempts to flee or pushes them. Prosecuted. Police officers who use excessive force may be held criminally and civilly liable. All right, this is some important information. Here are the guidelines. Courts consider whether an officer's use of force was reasonable based on the crime's severity, whether the suspect posed a threat, and whether the suspect fled or resisted. A question in which I wish there was no reason why I have to ask this. Is the use of lethal force by police legal? Only officers with probable cause or those who have been threatened with a weapon may use deadly force to apprehend a suspect. Third-party protection can also be achieved by lethal force. Lethal force cannot be used in an attempt to arrest a felony suspect. In public policy, it is better for police to let some felony suspects flee than to kill them. In high-speed chases, can officers use lethal force? By using deadly force to stop the car chase and arrest fleeing motorists, police officers can protect innocent bystanders from harm. To learn more about this, please look up Plumhoff versus Rickard. A car may be shot by an officer in self-defense. In addition, an officer may fire into a moving vehicle to prevent a dangerous suspect from escaping. Woohoo! That's been a lot of information. We are towards the end and what I feel like is some pretty dang important information. So, lastly, let's discuss the slippery slope called Do Arrestees Have a Right to Defend Themselves Against Excessive Police Force? Keep in mind, I'm not an attorney, nor is this legal advice, so don't go pointing your finger at me if you kick some cop's booty. But in case of excessive force by police during an arrest, the arrestee may be entitled to self-defense. The good news is, probable cause is not relevant here. Self-defense should only be used when necessary to prevent injury or death. No shocker here. In most cases, arrestees are blamed for causing the scene. Self-defense should always be a last resort. In a perfect world, wouldn't it be nice if none of this existed? Wouldn't it be even better if everybody took responsibility for what there is for them to take responsibility for? Man, what a difference that would make. What would our world look like if we all created ourselves as equals? If we all gave up judgment and our righteous opinions and saw everybody through an empathetic lens? We're all humans. We're all on our own journey to learn and grow. And let's just hold space for everybody to do that. For more videos like these, please like and subscribe to our social media channels. And I request that you share to fulfill the mission to get this information out to everybody in our world so we can know our rights and stay safe around the police.